This is David Healy, joined today with Robert Ingold on my left, David Appleby on my right. This is the 2021 Client Care Program Seminar. So the first thing you notice there is I did not use the phrase review and safekeeping. We have updated the name to Client Care Program. Bob, would you like to tell us a little bit about why we started with review and safekeeping?
Sure, David. Back in the early 1990s, when my practice was expanding, I had a practice of providing my clients with an original set of their estate planning documents, and soon discovered that clients were having a hard time keeping up with their documents, and oftentimes they would call my office and request a copy of their originals. And of course, I had to explain to them, well, I did not keep your originals, you have your originals. So we developed a system of maintaining a full set of original documents at the office, and that way clients and their families would always have access to those documents when needed. We also expanded that concept to include a bundle of services, periodic review of estate planning, documents, telephone access. We would encourage our clients to call during reasonable hours, but that's the concept. Was we wanted to be available and accessible to our clients from time to time to be sure that their documents were up to date and accessible.
I think this new title, CCP or Client Care Program, better describes this program that's evolved since the beginning. Things like everything, things change in life. And of course, we've expanded that and there's more coverage. So now it's not just the reasonable number of phone calls. And of course, the fact that we're always going to protect your documents and keep them safe to the best of our ability. But in addition to that, of course, we have the annual workshops. We'll talk a little bit more about that later, I think. But we also, of course, have a discount program for our members so that on any further estate planning matters that you've got, so long as you're in the program, we're going to do a 10% discount on those things that we do for you. You get the annual letter, update, things change. We want to keep you advised about that, and we provide that. And then, of course, as Bob points out, a key thing here is the reasonable phone access. My experience has been that clients sometimes don't call because they think they're going to get a bill from us for that. And we don't want to do that. We want you to feel free to call and have access to us. And I know, by the way, and I've said this before, nobody wants a lawyer that doesn't have something else to do. So when we say reasonable phone access to us, that doesn't mean somebody's always here to answer the phone like a phone bank. But that said, we'll try to get back to you within 24 to 48 hours. We get a high volume of phone calls anyway, but we try to get all those phone calls answered within the next day or two. So again, I just think this is a great idea to change the name now for this evolved program.
Okay, so going forward, Client Care Program is the name that's going to be associated with storing your documents, being accessible. And what I always like to tell clients is when we first sign the documents, we're building a relationship with them. It is our intent to be there till the very end and to make sure that we always have their documents, that we know the story of their life, the story of their estate plan documents, why they're written the way they're written. And it's an intention to build a relationship that we've built on for years to come. So let's move into what the seminar is today. For 2021, the name of the seminar is Estate Planning in Uncertain Times. So that probably doesn't come as a surprise to you. 2020 was a very uncertain year between COVID and riots and looting and burning and then a change of political administrations. A lot changed in 2020. And moving into 2021, there is some uncertainty. Now, Mr. Ingold actually made a comment early this morning that I thought was very on point for what we're talking about today, and that fear and greed are the two emotions that should never be associated with estate planning. So fear is kind of the one that keyed in on there, that should not drive anybody towards any drastic changes in their estate planning. But we're going to talk to you today a little bit more about things that we should be keeping track of. Now, this isn't the first time that we've seen uncertainty in both our world and the estate planning practice, correct, Bob?
Well, that's true, David. We've had uncertainty all through life. We can all attest to that. We can look at the national and the international scene. We can look back to the 1970s, for example, with the Arab-Israeli War of 1973, and we can look at the gas shortages and the long lines we had to endure in order to purchase gasoline for our automobiles, and we can remember the Iranian hostage situation and so many different calamities. The tech bubble that emerged in the late 1990s that so adversely affected investments with its collapse there in the early 2000s, and then 2008 we had the collapse of the real estate bubble. So we've had many national and international calamities in times past, and of course life is full of uncertainties as well. But as David has mentioned, it's best to engage in a conversation related to estate planning when you're not in a crisis mode, and it's good to be prepared for those occasions when we do encounter difficulties like the COVID crisis.
I think Bob's absolutely correct. We've had a lot of uncertain times, not just in terms of our nation, if you will, or the entire society, but individually. And Bob alluded to that. And you know what's amazing to me, having been here for several decades now, is the fact that our clients and those that provide services to them, to include us, but also their accountants and the financial planners and others that might be involved, we've always been able to adapt. We've always been able to take those adversities, if you will, and we've always been able to figure out a way to work around those things. But as things change, we do have to take a hard look at our estate plans to be sure that we have adapted. So when those things happen, it's important to continue to look forward and make revisions as necessary.
So part of the client care program is a review of your documents, both as necessary and just every few years, every 3 to 5 years, we like to see our clients come in, make sure there's no changes that really need to be made. David, when clients come in for a review, interview or review consultation, what should they expect in that meeting?
Well, I think we're going to take a look at everything. You've got a comprehensive plan, most of you that will see this program. You've got a trust or a couple of trusts perhaps. You've got pour-over wills, you've got durable powers of attorney. So we're going to take a look at all those things and just be sure that based on your dynamic life, as things change, that we can meet those changes. So people move, people die, people close to us, people lose their jobs, people move. So it's just important that we take a look at all that and kind of see where you are in your life right now, and then we make those revisions to reflect the way your life is right now. And I often tell people this, so many people seeing this have heard me say this, but think about the last 10 years of your life, think about the last 20 years of your life, think about all the things that have happened that you didn't anticipate. So why wouldn't we think going forward every 5 years, 10 years, or 20 years that an equal or greater number of things are going to happen that we didn't anticipate? So we're going to kind of get an update from you about where you are and where your family is and your health and your financial situation, and then we're going to change those things to meet where you are at the time we do the review.
And in addition to changes in your personal life, one of the things that we always want to review and discuss with you is updates in the tax law. So the letter that you have in your hand at this point should review some of the 2020 tax law changes, a lot of which are temporary and listed out in the letter as being part of the CARES Act and very temporary in nature, but things you should be aware of. That also gets integrated into that meeting. Review your documents to make sure that we are still planning for the correct estate exemption amount. And that's a number that is likely to change under the Biden administration. It's something that we are watching closely here. And then, of course, in addition to personal changes and tax law changes, Bob, we have societal issues, COVID, for instance.
Yeah, absolutely. I had a friend recently contact me and very concerned about his wife who has Alzheimer's at the age of 71. She's suffering from Alzheimer's disease, and he's very concerned about her medical durable power of attorney and how should that document be worded and crafted in light of the COVID crisis.
So in part of that COVID crisis, I want to just make a comment. The Missouri legislature, I believe, did an excellent job of responding to it with some emergency legislation to allow for remote notaries. And we've had that question asked here at the office if that's something that we can do. And we are not participating in the online or remote notary service. That legislation was crafted potentially a little too quickly. Again, very well intended, but it leaves some very critical issues or concerns here from the legal staff, the two attorneys sitting here with me, as well as many seasoned and experienced estate planning attorneys in the community that we have consulted with. Very few that I'm aware of are actually utilizing the remote notary law to sign estate planning documents due to the high risk of litigation coming out of that.
Yeah, these are uncertain times. I know we keep saying that, but I think adding potentially more uncertainty by trying to use some of these hastily crafted, I don't say poorly crafted, but hastily crafted laws, and very often things that are done in haste, as we all know, are going to have some long-term implications that we're not going to be happy with. And I think David's absolutely correct when he says this law, while it is a law and can be done, is probably to the benefit of lawyers that do a lot of litigation, because I think that's the, and by the way, anytime you've got laws that are only to the benefit of lawyers and not everybody, those typically are not very good laws, okay? And so this is something that I think will change and be changed, and perhaps they can come up with something in the legislature that we can sign on to and feel comfortable with for our clients.
Yes, I agree that the best policy is to have an in-person notary, and you remove so many questions and concerns about the authenticity and the reliability of the documents when you have the in-person notary.
Kind of the bottom line with all of this is we are absolutely looking out for your best interest, and quite practically what might be the most convenient answer is probably not going to be the right answer in that scenario. And here at the office, we will definitely work with you as best we can, but we have decided that the remote notary is not necessarily in our client's best interest to participate in. I'm going to go ahead and move forward to cover a few areas that were covered in the letter. At this point, you should have that letter in your hand, but a couple of things were important enough in that letter I want to just say something about them today. First one is there are no required minimum distributions in 2020. I have talked to a number of clients who have asked a very good question of should they plan on that not happening in 2021. The quick answer is absolutely not. I do not believe they're going to waive RMDs in 2021. I do not believe the government can afford to do that financially. I think it's going to be a practical issue there. Of course, I could be wrong. We're sitting here in January of 2021. We are one day into the Biden administration, and things could change very quickly in that light. But I would urge all of my clients to not anticipate there not being a 2021 RMD. It is all but a certainty in my estimation that those will be required and that those will be drawn from your account and taxes paid on those. The other big change from 2020, it kind of came to light, is in the past, you could do a Roth conversion of your tax deferred account, and then should the market drop, a pretty common technique was to turn around and undo it. And therefore you get a refund back, a partial refund of the taxes paid. Again, that has changed. Once you make your Roth election, there is no undoing it the following year. And that's something you need to talk to your financial planner about and your accountant about before enacting. But you just need to be aware that once you make that Roth election, you cannot simply go back in time and undo it to your personal benefit. That's no longer being allowed. Other things that I found of interest over the past year, long-term effects of the Tax Cut and Job Act of 2018. As predicted, fewer and fewer Americans are filing itemized deductions. Most of you are pretty keenly aware that for years you would have a box full of receipts and pages of deductions you took. That has been replaced with a standard deduction now of several $1,000s that for most people exceeds their deductible expenses and charitable bequests. So right now in 2019, the first year they were able to track those numbers, they saw that only 11% of Americans took itemized deduction. That is a drop from right at half before that, so a significant drop. Other things to be aware of, if you're a business owner, I'm sure you have talked to your tax preparer about bonus depreciation. If you haven't, you need to. There is a growing list of items now that have a lifespan of 20 years or less. You can take what's called bonus depreciation. That means you write off the entire purchase in year one. So that is a huge advantage to business owners. That was part of the Tax Cut and Job Act. with an emphasis to increase investment back into your small business. I'm seeing a growing number of clients come in that have Bitcoin and similar digital asset accounts and questions about how to handle those. Probably the biggest thing I would really urge clients to be aware of, those are not tax-free transactions. I believe for years people probably were able to transact with Bitcoin and other similar digital currencies with no tax implications. The IRS has actually created a unit to audit these transactions. It is a growing focus as more Americans participate in these markets. It's grown, their focus has grown to the point there's now a line item on page 1 of your 1040 starting this year in 2020 tax returns asking you about any digital currency transactions you partook in. Other things to be aware of is that there have been a number of subpoenas served now on cryptocurrency exchanges. Those were fought in the court system. They all lost. They have all had to turn over their records to the IRS about who they're doing business with. So this increased focus, kind of the bottom line is everybody just needs to be very keenly aware that the IRS is going to expect you to report those type of transactions. They are going to expect the exchanges to send you a 1099, just like any other brokerage account would, and you will pay taxes, both short-term or ordinary income taxes and capital gains on those transactions. Charitable donations in 2020 were impacted by the CARES Act. This is, again, something that probably is not carrying forward into 2021. This is more on point when you file that tax return for 2020 to be aware of. But part of the CARES Act indicated or stated that donations made to 501c3 organizations are 100% deductible. There are some limitations on that, so I'm not going to tell you that all of your donations are 100% deductible. Your tax preparer can assist you with that, but it is a question to ask and just follow up on to make sure or to discuss how those charitable deductions are being reported on your tax return, as there is a pretty high likelihood that the majority of them could be 100% deductible. Conservation easements is another issue I'd like to talk with you about today. Conservation easements have been around for a number of years. Mr. Appleby here in the office has a very astute saying that good tax laws sometimes lead to people showing up, the analogy here is to a pig at the feeding trough and ruining it for everybody else. And that is essentially what's happened with the conservation easements. The intent here is, of course, is that we are going to protect certain properties from development to make sure that they are here for our children and grandchildren. But unfortunately, they have turned into financial investments with unseemly returns, and they've been abused to the fact or to the point that there have been attorneys and CPAs federally indicted now who have put together these, at this point, they're simply tax schemes returning 3, 4, 5 times investment on your tax returns. That was never the intent of these conservation easements. Federal court system, not surprisingly, has come down harshly on these accounting and law firms that were selling these easements and helping people through that process. The federal government has indicted tax preparers and attorneys assisting with this, but to this point in time, to my knowledge, no taxpayers have been implicated in any of this. There is, in the IRS world, an innocent person defense, and that's what you would be if you were misled by an accountant or an attorney that this was a safe investment. They are, however, reaching out to people who invested in conservation easements that were illegal. And again, they were not all illegal. If you have participated in one of these, that does not necessarily mean that the one you participated in was illegal. It's the ones that are simply too good to be true. And that is probably fairly self-evident. So the IRS has taken the position of allowing taxpayers who were misled into believing these were safe and legal investments to extricate themselves from this. And of course, there's a penalty to be paid, but it will keep you out of court. We just simply state if you get a letter from the IRS regarding a conservation easement transaction you've been engaged in, please call our office. We'll walk you through it. I don't anticipate there are very many, if any, of our clients that would be in this class, but I would urge you to take that seriously if you receive any mail about those. The other things I was going to cover with you out of the letter are primarily going to be kind of more of the planning side of things, what to expect in 2021. A lot of uncertainty with that. the Tax Cut and Job Act was set to expire or sunset in 2025. The Biden tax plan, on which President Biden ran on, is probably going to make changes sooner than 2025, and we are expecting those and anticipating those. That's simply something we do not have enough information about sitting here in January 2021, one day into the Biden administration, to be able to give you any definitive advice on, other than simply watch your mail from our office. This time next year, I would anticipate we will be discussing the Biden tax plan and what it means to you. Now, on a more practical note, Mr. Appleby is going to talk to us for just a minute about powers of attorney.
Thank you. David, you've identified this correctly. This is a practical problem. It's not a legal problem. And it relates to powers of attorney, both the financial or general or business power of attorney, as well as health care, I think. Let me tell you that under Missouri law, there's no expiration date on your powers of attorney. Once you do it, it's in full force and effect and remains so unless you revoke it or amend it at some point. And generally speaking, it only terminates at your death. So if there is an expiration date on it, it's your date of death. So that's the Missouri law, but there is a challenge here. And I noticed this a year or year and a half, maybe almost 2 years ago, as I watched the seminars and speakers came from all around the country, and there was discussion about the fact that just kind of nationwide, banks are starting to not honor powers of attorney, and those questions were coming from the audience. And so I hear lawyers in California, I hear lawyers in Illinois, and I hear lawyers in New York, and they're talking about the fact that banks. Now, some of the discussion was that their insurance carriers were suggesting that if it's too old, in their opinion, okay, they should not honor it. So this idea of, well, if it's more than 10 years old, maybe we don't want to honor that. Well, I think what we're seeing now is that trend that started in the bigger cities and on the East Coast has now reached here. And we're now seeing that there are banks, particularly as banks are bought by bigger banks and bigger banks are bought by huge banks, that we're now seeing a lot of policy, a lot of procedure that's flowing down to local banks, if you will, where you bank, the branch where you go, that they're now saying, well, we don't know if we're going to honor that or not. And by the way, it also even happens with some insurance companies. The insurance companies don't want to honor that if you want to make a change using a power of attorney. They want to look at the date on that too. And there's discussion that in some cases the policies are going to be if it's over 5 years old. So none of this is law. It's just a practical problem that despite the fact that your powers of attorney are in force by law in Missouri, it doesn't mean that an institution is going to accept that. And by the way, this goes to your health care too. I've had more of this recently with regard to health care. And of course, we have two major health care providers here in Southwest Missouri. And I've had inklings and a little bit of pushback at both of those institutions with regard to when the power of attorney is in effect, if it's more than 10 years old, or your living will or declaration or DNR or healthcare directive, whatever title you want to put to it. Of course, in Missouri, it's actually a declaration, but it's been kind of the same thing. So this almost goes back to this periodic review. When you come in, if it's, we say every 3 to 5 years, it may be that you're going to want to pay us a nominal amount in terms of lawyers' fees to go ahead and update those, if nothing else, changing the dates, even if you don't have other changes, as opposed to waiting and down the road, we have to challenge the bank or we have to challenge the hospital in court to the tune of thousands and thousands of dollars. So this is a looming problem. And so we just need to be aware of it. And on powers of attorney too, I might add, you know, we have had some changes. There have been some new laws, and the one that always jumps out at me is the right of sepulcher. We've always told you that your powers of attorney terminate at your death. But you can have authority in your power of attorney for the disposal of human bodily remains, right of sepulcher, so that your agents under the power of attorney can go ahead and take those measures to have you cremated if you want, or consent to an autopsy, or make an anatomical gift, so that an exception to that, and by the way, there are starting to be other exceptions to your powers of attorney, like access to medical records if it's included in there. So it isn't just the date on there as a practical matter. There are some legal reasons to pull your power of attorney, if nothing else. As soon as you hear this, honestly, pull that power of attorney out and look at it, and that may be the most important document to update right now.
Absolutely. Bob, would you like to talk about client seminars this year?
Well, I hope you found this information today to be beneficial. Unfortunately, as you may have suspected, we're not going to be able to offer dinner seminars in 2021. This is very disappointing to us, since we always look forward to renewing acquaintances and staying in connection and contact with our clients at our annual dinners. However, between our concern for your health and the practical issue of securing a venue willing to host our seminars, we're simply not going to be able to provide seminars this year. We're hopeful that in 2022 we'll be able to resume our dinner seminars.
Now, COVID is still a concern here in the office. David, would you like to
Sure.
talk to us a little bit about that?
Well, first let me say something about the fact that we're not wearing masks, and we know that, and we had them on until we came in here. Everybody else in the office is wearing those, but we thought for this brief period of time, it would be better that you'd be able to see and hear us as opposed to wearing the mask. So much like your TV announcers and others, perhaps, we're not wearing a mask. That said, when you come to our offices now, and many of you are aware of this, we may ask you if we can take your temperature, okay? Because we want to protect everybody. You'll notice that we do wear masks here. We ask that you wear a mask, and we're going to wear a mask. When you arrive, if there are multiple people in our conference or in our waiting area, which is relatively small, or at least puts people in close proximity, we're going to try to immediately put somebody in a conference room, kind of a holding area, so that you're not in close contact with other than your own family members or friends that are with you. We are, on a personal note, between every client, I go downstairs and wash my hands. In addition to that, we take in the waiting area as soon as it's empty and people have moved, and in each of our conference rooms and our offices that are upstairs here, we wipe all those down with disinfectant. If you didn't take your pen, we encourage you to take your ink pens we give you, because that's advertising for us. But if you didn't carry your pen off like we'd like you to, we're going to wipe those pens down. We wipe off the desktop. We wipe down the chairs and the arms of the chairs. We wipe down the door handles, okay? And we do that between each and every client for your protection. So as many of you, I think, know, but if not, let me share with you that when all this started, of course, certain groups or entities were exempt from having to shut their doors, and that basically was because you were deemed to be essential. Well, our law firm, because of some of the people that we support, the real estate industry particularly, we were exempt. So our firm did not shut its doors even a single day. Now, we did a lot of telephone appointments some months back, that's true, but we didn't ever shut down. We didn't send anybody home to try to work from home. When we have experimented with that, it frankly didn't work very well in our industry, we didn't think. So we've been open every day, and we've been doing all these things to try to protect you, and we want you to feel safe here. We want to feel safe. We have a lot of employees here that we want to protect also. So if you'll just continue to bear with us, we're going to continue to take all those steps for your safety and our safety.
And speaking to that, 2020 was a little bit of a rough year in the office as far as staffing, and we think we had those issues just basically resolved through, I think society has figured out how to work better in these times, but due to rolling quarantines, I think there were periods of time we had less than half our staff here for much of the year, and I believe the school system has kind of figured out a better system, which was a lot of that issue of employees who had children and had to be home with them. So things have kind of settled down a little bit. We all live in a little bit different world today than we did this time last year, but we are adapting. As Mr. Appleby just told you, we're looking out for your health as best we can here. And Bob, you want to talk to us a little bit about retirement, how that's
Yeah,
been?
well, it's been great, David. I sure appreciate you asking me about it. We've been planning for this and facilitating it over the last 4 to 5 years. So it's been a process, and I think it's been a very good process, an orderly transition of my practice to Appleby Healy. And I'm very confident in this law firm. I've just have always had a great respect for David Appleby and the Appleby Healy law firm. And so I feel like my clients that started out with me are in good hands now with the law firm here. At one time, I had even joked about practicing up to the age of 100, but in recent years I had second thoughts about that with grandchildren living in the Little Rock, Arkansas area, grandchildren living up in the Kansas City area, and there's so many activities Patty and I would like to be involved in. So we've been in a transition mode, and in fact, a year ago, December 31st, I went inactive with the Missouri Bar. So I'm officially in a retirement status and enjoying it very much. You'll have to ask Patty how that's actually working out in our household, but as far as I'm concerned, it's been great, and I've thoroughly enjoyed it, and I do miss the interaction with my clients, and I wish all of you the very best going forward in the future.
Great. Well, retirement's a goal that most people have, and glad to hear that Bob has been able to enjoy that. Please call us if we can help you with any legal needs. We have expanded our litigation team to include 3 attorneys, so we are in the courts in Southwest Missouri handling a variety of matters on a daily basis. And we're still local lawyers here to help local people since 1924.